There's some dismissals on the computer that the state has filed. When I call your name, I need you to come forward. There's an X in front of the in front of the bench. Detrell Brown, this is cause number 320734. Okay, Mr. Brown, your full name is Detrell Brown. How you doing, Mr. Brown? That's good. Mr. Brown, I have a dismissal that was filed by the state of Texas. Is that correct?
That's correct.
Mr. Johnson? Okay. Mr. Brown, your case has been dismissed. Please stand on the X in front of our court coordinator, the far X over there. She's going to give you the dismissal. Once you get your dismissal, you'll be free to go, and you have a blessed day. Ashley Sierra Bias. That door is locked, Mr. Brown. You got to go through the door you came in. Okay. Miss Bias. This is cause number 322528. Case is styled the state of Texas versus Ashley Sierra Bias. Miss Bias, is that your full name?
Yes.
How are you doing, Miss Bias? I'm doing fine. Thanks for asking, Miss Bias. I have before me a motion to dismiss. State, did you file this motion to dismiss?
We did, Your Honor.
Okay, now, Ms. Bias, the state has filed a motion to dismiss your case. You're gonna get a copy of that dismissal from the court clerk, from the court coordinator. Once you get a copy from the coordinator, you'll be free to go, and you have a blessed day. Please stand over there. You can leave that clipboard on the table.
Okay, thank you.
Next case is cause number 333062. Case is styled the state of Texas versus Claire Louise Stevens. Okay, Ms. Stevens, your full name is Claire Louise Stevens.
Yes, sir.
How you doing, Ms. Stevens?
Good, how are you, sir?
I'm doing fine. Thanks for asking. Now, Ms. Stevens, I have a motion to dismiss that was filed by the district attorney's office. State, is that correct?
That's correct, Your Honor. The complainant witness case and requested dismissal.
Okay. Now, Ms. Stevens, your case has been dismissed.
Yes, sir.
You can leave that clipboard on the table. And you're gonna get your copy of your dismissal from our court coordinator. Once you get a copy of the dismissal, you'll be free to go and you have a blessed day.
Where do I put the, okay.
Right there on the table in front of you.
Thank
Okay, you're free to go.
you.
Hold on a minute. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2 of Jefferson County, Texas. You have been asked to come to court today for what is called an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. The case that you have in this court is a misdemeanor case. Felony cases are divided into, criminal cases are divided into felonies or misdemeanors. Felony cases are referred to as your most serious type cases and or more serious type offenses, whereas your misdemeanor offense are referred to as your petty offense. Now, it does not mean that they are not serious. It just means that they are not as serious as the felony offense. Now, when I talk about the seriousness, not only are we talking about the facts of the case, but we're also talking about the punishment range. That is, what your punishment can be if you are convicted in the case. Now, for example, felony cases are divided into 5 categories. The highest felony is a capital murder. Then you come down to first-degree felony, second-degree felony, third-degree felony, and a state jail felony. If you're convicted of a state jail felony, the range of punishment is confinement from 6 months to 2 years in the state jail, a fine up to $10,000. If you're convicted of a third-degree felony, the range of punishment is confinement from 2 years to 10 years in the state penitentiary, a fine up to $10,000. If you're convicted of a second-degree felony, the range of punishment is confinement starting at 2 years to a maximum of 10 years, to a maximum of 20 years in the state penitentiary, and a fine up to $10,000. Now, if you're convicted of a first-degree felony, the range of punishment starts at a minimum of 5 years to a maximum of 99 years to life in the state penitentiary, and a fine up to $10,000. Now, if you're convicted of a capital murder, the range of punishment is either life or death. Now, for your misdemeanor cases are divided into 3 categories. You have the highest category, which is a Class A misdemeanor. Then you come down to Class B. Then the lowest misdemeanor you have is a Class C misdemeanor. If you're convicted of a Class C misdemeanor, the range of punishment is fine only. You cannot be given any jail time. You can only be sentenced to a fine only. However, if you do not pay your fine, they can issue what is called a capias pro fine. And with the capias pro fine, you can be sentenced to serve out the jail time on the fine until it's served. Now, the Class B misdemeanor, the range of punishment is 0 days to 180 days in the county jail, or fine up to from $0 to $2,000, or you could be given both such fine and confinement. If you're convicted of a Class A misdemeanor, then the range of punishment is 0 days to 365 days, which is a year in the county jail, of fines from $0 to $4,000, or you could be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. And one of the rights that you have is the right to have an attorney. The paperwork that has been handed out, that's on the clipboard, it talks about your right to have an attorney. And I will go over that paperwork with you. Now, as a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number 3, you may represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset, means that you'll be given another court date so that you can be given enough time to hire your attorney. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire. That financial questionnaire is the document that's on that clipboard. It's titled Jefferson County Affidavit of Indigent. You would have to fill out that document so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you want to represent yourself, that is, you want to waive your right to an attorney, give up your right to an attorney to represent yourself, you may not speak to the prosecutor, and the prosecutor is the assistant district attorney that's handling the case. And he's sitting at the table in front of us, or in front of you. That his name is Attorney Lamar Johnson. He's the prosecutor in this case. Now, you cannot speak to the prosecutor unless you sign a written waiver of your right to be represented by an attorney. Now, what a waiver is you're waiving your right, or you're giving up your right to have an attorney to represent you, and you will be representing yourself. So in order to speak to the prosecutor, you have to first sign a written waiver of your right, indicating to the court that you are desiring to represent yourself. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to proceed without an attorney, that is to represent yourself, you may change your mind at any time and may request counsel or request an attorney from the court. At the bottom of that document, it states in bold letters, defendant's choice. Mark initials next to only one choice. Now, if your choice is you want to reset this case to hire your own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If you want to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney, that is, if you want to give up your right to have an attorney and to represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled defendant, and you will date it today's date where it says date, and the day's date is December 13th of 2022. Now, for those of you who will be waiving your right to an attorney or giving up your right to an attorney and representing yourself, you would have to read and sign the second page that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And I will go over this document with you as well. And it reads, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily, meaning that I'm doing it of my own free will, and intelligently, meaning that I know what I'm doing. So my waiver is voluntarily and intelligently made. Furthermore, I have been advised this 13th day of December of 2022 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. And if that's your choice, it states I hereby waive my right to counsel. And if that is your choice, you will sign on the line that says defendant, and you will date it today's date, December 13th of 2022. Now, the document that talks about Jefferson County affidavit of indigence, I will go over that document with you later on. Next, you not only have a right to have an attorney, you also have a right to have a jury trial. And what a jury trial is where this gentleman is sitting in that area over there. We call that the jury box. 6 citizens from Jefferson County will be selected to sit in your case, and they will decide after listening to all the evidence whether or not you are guilty or innocent, or guilty or not guilty. Now, you also have a right to waive your right to have a jury trial or to give up your right to have a jury trial. And if you do so, you will not have a trial by jury. However, your case will come before the court or before the judge in one of 3 ways. One of the ways it can come before the judge is by way of a bench trial. A bench trial is a trial by judge only. The judge will listen to the evidence and the judge will decide whether or not you are guilty or innocent after guilty or not guilty after listening to all of the evidence. Your case will also come before the judge by way of a plea bargain. It could be by way of an agreed plea bargain or an unagreed plea bargain. So it can come before the judge by way of an unagreed plea bargain. That simply means that you and the state have not been able to reach an agreement, and therefore you would like the judge to determine what your punishment will be in your case. Now, the other way that your case will come before the judge is by way of an agreed plea bargain. An agreed plea bargain means that you and the state, or you and the prosecutor, have been able to reach an agreement to settle your case. And you would like the judge to go along to follow that agreement. Now, the judge does not have to follow that agreement that you've reached with the state. Now, if the judge does not follow the agreement, you'll be entitled to take back or withdraw your plea that you made. Now, if the judge does follow the plea bargain agreement, and if you decide within 30 days after entering your plea that you would like to appeal your case, what an appeal is, you would like to have a higher court to look at your case, then you have to get permission from the judge. Now, if the judge give you permission to appeal, then your case will go up on appeal to the Ninth Court of Appeals, which is right above us on the 3rd floor. They will review your case. They will decide whether to grant or deny your appeal. If they grant your appeal, then they can simply find you not guilty and your case will be over, or they can send the case back down to this court and order this court to give you a whole new trial. Now, if they deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeal. In essence, you can appeal it to the highest court, the highest criminal court in the state of Texas, which is the Texas Court of Criminal Appeals, located in Austin, Texas. Now, you would have to file what is called a pro se petition for discretionary review. Pro se petition for discretionary review, a pro se basically means that you'll be representing yourself. You'll be filing this petition without the assistance of an attorney. You'll be filing it on your own, and you'll be asking the Texas Court of Criminal Appeals to review your case to see whether or not your appeal should have been granted, whether or not you've been wrongfully convicted, or whether or not this court committed an error by convicting you. They can do one of two things. They can grant your pro se petition, and if they do so, they can simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial, or they can deny your petition, and if they do so, at that point, your conviction will be final. Now, you also have a right to have what we call witnesses to come to court. You have a right to call witnesses to your trial. Witnesses sit in that chair over there. We call that the witness stand. Witnesses can testify for you or against you. If you're representing yourself, you can ask them questions, or if you have an attorney that's representing you, attorney can ask them questions, and we call that either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses to come to court. In essence, you have a right not to call any witnesses in your case. Now, just because you will not be calling witnesses does not mean that the state will not be calling witnesses. The state will be calling witnesses in the case that they have against you. Now, you also have a Fifth Amendment right against self-incrimination. That means you have a right not to testify against yourself in your trial. The state or the government cannot force you to testify against yourself if you invoke your Fifth Amendment right against self-incrimination. Now, I know you may have heard it referred to as taking the fifth. When people say I take the fifth, it means I'm not testifying. In essence, I'm invoking my Fifth Amendment right against self-incrimination. Now, you can, as I said, you can waive or give up that right. And if you waive that right or give up that right, you will be testifying in your case. You also have a right to have what we call discovery. Discovery means you have a right to see the evidence that the state has against you. And you have a right to see the documents, witness statements, any police reports. You have a right to see videos, any tape recordings. You have a right to see, I have access to objects, anything that they have that they're going to use against you in your case. You have a right to see that evidence. Now, you can waive or give up your right to discovery as well. By waiving or giving up your right to discovery, that simply means that you will not like to have access to the evidence that the state has against you. Now, everyone that's here today for arraignment, you have been arrested, you've been to jail, and you're out on bond. You're either out on what we call a cash bond, which means you paid the full amount of the money to get out, the full amount of the bond to get out of jail, or you pay a surety bond, which means that you paid a bondsman to get on your bond, and you paid him a percentage of what that bond in this case was or is. The other thing is you may be out on what we call a PR bond, personal recognizance. That's what PR means. That means that you did not have to pay any money to get out. You was released on your personal recognizance with a promise to appear in court when your case came up for court. Now, every day that you spent in jail, that jail time can be used as credit towards your punishment. So, for example, if you spent 5 days in jail, and if the state is offering you 5 days in jail, that simply means that you would not have to serve any more time in jail, because you will be given credit for the time that you have already served, and you'll be given credit for time served. Now, if they are offering 7 days in jail and you spend 5 days in jail, that simply means that you would have to do 2 more days in jail. Now, every day that you spent in jail also is credited as $100 per day towards your fine and court costs. So if the state is offering you to pay a fine and court cost of $500 and you spent 5 days in jail, 5 days in jail is $500. That simply means you will not have to pay any money towards your fine and court costs, because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Now, if they're offering $700 fine and court costs, and if you've been in jail 5 days, which is $500, that means you would have to pay $200. You'll have to pay $200 on the day that you dispose of your case. Now, if you cannot pay the $200, then the law allows the court to set up what is called a payment plan. In essence, you will pay in monthly installments the amount of the remainder, the amount of the fine and court costs that you owe. Now, if you cannot pay the fine and court costs, then the court can convert your fine and court costs to community service. And that is, you would have to work at a nonprofit organization, and every hour that you work at that nonprofit organization, $12.50 will go towards your fine and court costs. So if you work 8 hours at a nonprofit organization, then that will be $100 that will go toward your fine and court costs. Jefferson County has a program for people who have not been in trouble before, for first-time offenders. That program is called pretrial diversion. And with pretrial diversion, Jefferson County DA's office will dismiss your case, and you can get it expunged from your record. Expunged means erased, wiped off, or deleted from your criminal record. Now, in order to qualify for pretrial diversion, it has to be your first case. It cannot be a case involving unlawfully carrying a weapon or resisting arrest, and you have to have an attorney to assist you to get into the program. Now, if you are a veteran of any one of the branches of the United States military, Jefferson County has a program that is called Veterans Court. It is also part of the pretrial diversion program. With that program, your case is dismissed. You complete the program. You can get it expunged, which means erased, deleted, or erased, or wiped off from your criminal record. And in order to get into that program, you just have to be a veteran of any one of the branches of the United States military. Now, this court, County Court at Law Number 2, has a program that I started within the first 100 days of taking office back in March of 2017. That program is called the CSI program. It means CSI stands for Community Safety Initiative. It is a program that is designed to address the issue of what we call recidivism. Recidivism simply means that people commit crimes over and over. And how do we address that? We address it through our CSI program. And with the CSI program, we have a partnership with agencies in our community. One of the agencies that we have a partnership with is the Spindletop Center. Spindletop Center is our local mental health center. And in order to qualify in that to get into that program, you do not have to be incompetent and insane. You could just simply have suffer from any one of several mental illnesses. For example, you could be suffer from anxiety, depression, paranoid, schizophrenia, or a whole host of other mental illnesses that you may have. They'll be able to address those mental illnesses by having a private interview with you. They'll they will do an assessment, and then they will develop a treatment plan, either outpatient or inpatient, to address your mental health needs. Now, if you have issues with drugs or alcohol, we have a partnership. Spindletop has a program that is called ATAR, stands for Addiction Treatment and Recovery. And our local Drug and Alcohol Council has a program that is called OZAR, stands for Outreach, Screening, Assessment, and Referral. And with that program, both programs, they will do a private screening. They will do an assessment, and then you will refer to, they will develop a plan to address your drug or alcohol issues, either outpatient or inpatient services, depending on what your issues are. Now, if you're unemployed and do not have a job, we have a partnership with the Golden Triangle Empowerment Center and they have a partnership with Lamar University, and Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in one of the areas that you select, either the hotel, the shipping, or the chemical industry, then they will assist you at getting a job in the areas that you're trained in. If you have not graduated from high school and you would like to get a GED, then the CICE program have a GED program, Graduate Equivalency Diploma program that you can get into. All of the programs that I've just mentioned, the program with Spindletop, the program through Lamar University, OZAR, ATAR, GED, all of those programs are free. It does not cost you anything. Only thing you have to do is have a desire to be in those programs. And the other benefit about those programs, all of those programs can be used as community service in your case. So for example, let's say you were ordered to pay a fine and you cannot pay the fine, and therefore we gave you you ordered to do community service. If you're in one of those programs, while you're in one of those programs, you're getting community service hours and you're paying your fine at the same time. And so I tell people this all the time, you're killing 3 birds with 1 stone. You're doing the program, you're getting community service, and you are paying your fine and court costs by doing one thing. So while you're working on your GED, you're paying your fine and court costs, and you're doing community service. While you're getting job training, you're doing your community service, and you also paying your fine and court costs. While you're in drug alcohol counseling, you're paying your fine and you're doing community service. And also while you getting mental health treatment, you're also paying your fine and you're doing community service. So you're doing one thing, but you're getting credit for 3 things. Now, all of those programs that I said are free. It does not cost you anything. Only thing you have to do is have a desire to be in the program. And I'll tell people this again all the time, that when you come to County Court at Law Number 2, we do not have court as usual. We have unusual court. And it's not because we're different, it's because we're trying to make a difference in the lives of the individuals that comes before this court, and we're trying to make a difference in Jefferson County. All of these programs, as I said, are free. And the other thing is, in County Court at Law number 2, we do not just give time. We take our time. We do not just arrest the problem, we address the problem. And the reason why is because we are designed to produce productive people. And we believe that if we produce productive people will not commit crimes. Why? Because they have too much to lose. So if you're interested in one of those programs, just let us know. We have brochures and we can provide you with the information that you need. Now, I have here Deputy Hinton, who is our local mental health officer. He's going to come before you and give you some very important information about the program that they have at Spindletop. At this time, I present to you Deputy Hinton. Deputy Hinton.
Thank you, Your Honor. Morning. The reason I'm here is the judge has invited me here. He's caring about every single person that comes before his bench. What the judge has found is those who appear with legal issues commonly have mental health, substance use disorders, or just a lack of community resources. The judge believes, the statistics prove, that we can help you with these underlying issues and which have a cycle of arrest. Now, maybe this is your first time being here, maybe this is your 10th time being here. There's still hope. That's a program that help you with that. You know, the flyer here is a little bit about the court programs and the benefits associated with taking advantage of it, but also it has a 1-800 number. Should you ever find yourself in a mental state place, you can call that number immediately. Get this to the recess. I also handed out this form to you earlier. It's a demographic sheet. It's HIPAA regulated. It's private. We will not share this information with anyone outside of your permission, but it will be used to help connect you to resources that will best benefit your situation. Now, we have no idea where you are in your walking life. So we're going to need you to do something and maybe a little uncomfortable. I'm going to ask you to work through that. Write down on that sheet information that you want us to talk about so we can kind of do some research before that. But we're going to need you to share that need with us. We just have no idea what you may need and how we can help you. But if you'll put that information down there, we also have a form, a place down there at the bottom that says that you can speak to us today. I can't guarantee that we can get to everyone today, but we will prioritize reaching out to you through a phone call, through a text, whatever you mark down there on how you prefer us to contact you. But if you don't remember anything I said this morning, I want you to remember this. We're here to help you. If you'll take advantage of this, we'll do and work as hard as you are willing to work for yourself. Thank you very much. Thank you, Your Honor.
Okay, thank you, Deputy Hinton. Now, ladies and gentlemen, those of you who will be applying for a court-appointed attorney, there's a form that is a financial form that's titled Jefferson County Affidavit of Indigence. And on that form, it has to be completely filled out where it says this portion to be completed by or with defendant. You will start there, and you would put your name, your date of birth, your address, your phone number. The next line asks whether or not you receive any type of benefits. So if you receive Medicaid, SSI, SNAP, TANF, or public housing, you'll check the boxes that apply to you. If you don't receive any of those benefits, then you will not check the boxes. The next line asks about your employment. And if you're employed, put yes. If not, no. And if you are employed, you say they're going to ask you where and what type of work. The next line talks about the number of hours that you work and how long have you worked at that job. Then we go to the next line. It talks about marital status, whether or not you're single, married, divorced, widowed, or separated. You check one of those boxes. And if you're married, you're gonna write your spouse's first name, middle initial, and last name. If you have any children from the age from 18 years old or younger, then you'll write and they're your dependent, then you put their name and their age. Where it says residence, it says rent. Now, if you rent, you own a home, or you reside with a family, or you're homeless, you check yes or no in the appropriate box. Now, at the bottom here where it says monthly income to the left, they say monthly income or assets. All of those lines need to be filled out. If you, and that's what you make per month. Whatever your take home pay is per month, you'll put that amount there. If you're not making anything, then you put a 0. Now, if you're married and your spouse has and is working, you put what your spouse is making. If your spouse is not working, you put a 0. If you don't have a spouse, you put a 0. Child support received, if you're receiving child support, you put how much you receive a month. If you don't receive child support, 0. And then it says SNAP, that's food stamp. If you receive, you put the monthly amount. If you don't receive, you put 0. Social Security, you put the monthly amount. If you don't receive, you put 0. Other government checks, if you receive another government check, you put that monthly amount. If you don't, put 0. And the other income, if you have other income, you put that amount, if your monthly amount. If not, put 0. Assets, that is, if you have a house or car, just state what the value of the house or the car may be. Now, and then at the bottom where it says total monthly income and assets, then you'll just total up everything that's in that column. So if it's all zeros, it'll be 0. If it's just your monthly income, it'll just be your monthly income, but you have to add that up. Now, on the right side of that form, at the bottom, it says monthly expenses, and that's what your expenses are per month. If you have to pay rent or mortgage, you put that amount. If you don't have to pay rent or mortgage, put a 0. If you have to pay utilities, gas, light, electric, or water, you just total that up and put it on the line that says utilities. If you do not have to pay utilities, it's 0. Now, total child expenses. Now, if you receive, if you're paying child support, or if you're paying other expenses for your children, you're going to add that up and total what you pay a month. Food expenses, that's what you have to pay out of pocket each month for food for you and the household. Transportation, now transportation costs, if you're paying a car note, you put that on there per month. If you paying insurance, you put that amount on there. And if you're paying for gas and repairs, you add all of that up and you put that under transportation cost. Now, where it says cell phone or your home phone, whatever you pay per month, you put that on in that box. If you're not paying anything, you put 0. Probation fees, if you have probation fees or parole fees, if you don't, just put 0. If you have any medical expenses or health insurance, you'll add that amount up and put it in that space. And if you have to pay any credit card payments per month, you'll put it in a place that asks for minimum monthly credit card payment. If not, you just put 0, and then you'll add up everything in that column for your total monthly expenses. Now, on the second page, it says defendant's oath. You'll put the day's date, 13th day of December 2022, and then you'll read that, and then you'll sign where it says defendant's signature date 12/13 or December 13th of 2022. Now, where it says unsworn declaration by defendant, you'll fill that information out. And once you fill that information out, you'll be finished. Okay? So now, if Mr. Kimberly, would you please be quiet? Okay, now, if anybody needs any help or any assistance with the paperwork, okay, then let us know. We have people on the staff who will be able to help you with the paperwork. And so while you're still filling out the paperwork, you need to make sure if you need any assistance, just raise your hand. We have somebody to come by to assist you at filling out the paperwork. And once you finish filling out the paperwork, we will pick up the paperwork from you. And then we're going to call each person up one at a time. And you'll either be in the category of wanting to hire an attorney, or wanting to apply for a court-appointed attorney, or wanting to represent yourself. And so once you finish filling out the paperwork, now, if you need to use the restroom or anything of that nature, there's restrooms outside in the hallway in front of the courthouse, in front of the courtroom, excuse me. The men restroom is front of County Court at Law number 3, which is to your right, and right across the hall from County Court at Law number 3. The female restroom is there, and that's in front of 172nd District Court. Okay, so at this time, the court will be in recess